Everyone can remain seated, court back in session.
All right. Seems like we're ready to go. Any preliminary matters before the jury comes in?
No, Your Honor, other than we would ask if we could take up the question of the hearsay exception with our proffer of proof.
Okay, you want to offer the proof now?
Yes, if we could, Your Honor. That way we could have the answer. If we could first call to the stand Detective Gish, and I think we will need to have Ms. Velazquez to step outside just because of the rule.
All right. Very well. Come on up, Detective Gish.
Do you swear to tell the truth, so help you God?
I do. Thank you.
And Your Honor, I don't know if this is all right with Mr. Hopkins, but in the effort of time, would it be all right for purposes of this hearing to stipulate as to the expertise of Detective Gish?
Yeah, now, you know, I should have mentioned that. I ordinarily do. I've had them stipulate Detective Gish so many times, I just let it slip my mind. You will stipulate, Mr. Hopkins?
Yeah, sure.
All right, very well.
Detective, did you have an opportunity to respond to the crime scene at 1229 Old Dickerson Pike?
I did.
And as a result of the police investigation, were you provided with a cell phone from the mother, Patricia Velazquez, in this case?
Yes.
And did she consent for you to do an extraction or examination of the contents of her phone?
Yes.
What in particular were you looking for?
Communication through the timeline. We knew when the victim was killed. So we started earlier that day to look to see if we could find any communication that may have come in from the victim to the mother or from the mother to the victim.
Okay. And were you able to actually find or locate communication between the mother, Patricia Velazquez, and her daughter, Johanna Ortega?
I was. There's a texting application on the phone called Google Hangouts. Basically, it's a messaging platform, kind of like Facebook Messenger, where if you have Google Hangouts and I have Google Hangouts installed, we can text back and forth through that application. And it was in that application that I found some interesting text messages that I thought Detective Hill should know about.
What was it that piqued your interest about those particular messages?
Well, the first message that I recovered was from the victim to her mother, and it was on 8/10 of 17 at 4:15 in the afternoon. It was in Spanish, but I used a translation, internet translation with Google Translate to translate the message. And at 4:15, the victim wrote to her mother, "Mom, someone is knocking on the door." And then at 4:19, the victim wrote back to her mother, "I think it was the man who cuts the yard." And at that point, I knew that was very important because I was at the crime scene and I knew that one of the suspects was the caretaker of the lawn.
And did you see any further text messages from the victim, Johanna Ortega, to her mother after that text that was sent at 4:19:13?
No.
Did you find on that device any return messages from Patricia Velazquez to her daughter?
I did.
And could you describe the details of what you
I
found?
don't have the time exactly right now unless you want me to dig through it. but
Would it refresh your recollection
It
to
would.
review your report?
It was after 6 o'clock. Yes, so it was roughly almost 2 hours later at 6:07 p.m. The mother responded to the victim, "Okay, do not make noise."
Did you see any response messages from the victim, Johanna Ortega, to her mother after that 6 o'clock text?
Unfortunately, no.
Now, did you have an opportunity to be presented to you for an examination, an iPad collected from the bed in the middle of the crime scene near where the victim was located?
Yes, ma'am. When we were at the scene, we knew that there was an iPad there, so we explained to the detectives what needed to be done, and that iPad was turned into us days later.
And if you would, could you describe what attempts you made initially to examine that iPad and what you were searching for?
Very few attempts initially, and the reason why is that it was locked with a 4-digit passcode. We were provided with a passcode, but it did not unlock the device. Knowing these devices, these Apple devices, after a certain number of passcodes, you can start to disable the device. Disable it to the point where it will brick, basically, is another word from not every opening again. So we knew we had to handle the iPad very, very carefully at that point. And we also knew that there weren't any software tools available to law enforcement that we knew of that we could actually purchase or use to unlock this iPad successfully.
And this was in 2017.
This was in 2017. Things have changed since then because we've had advancements like we do all the time in forensic technology where we would be able to more than likely unlock that iPad today. But in 2017, law enforcement agencies had to rely on one company, and it was the only company that we knew of at the time that could successfully unlock these iPads. Now, to say that, it's very, very expensive to have one of these iOS devices or Apple devices unlocked. But with the significance of the case, we knew that we wanted to try to recover the other end of those text messages, maybe to see if there was any other communication between the victim and the mother that may have been deleted off of the mother's phone or not saved in that database, and the circumstances of the case in general. So we decided to go ahead and send that iPad to a company called Celebrite, and I do off the top of my head, I think it was $3,200. So $3,200 is what we had to pay to send that iPad off to Celebrite to their lab in New Jersey. We sent that off, I want to say the first part of September. We received the iPad back a couple of months later and a full extraction. Now, they unlocked the iPad. They were able to provide us with the passcode, and they provided us with all of the data that was on the iPad. It was a massive amount of data. But they didn't do, of course, we didn't want them to do any analysis of the data. So they returned all of this back to us, and it was at that point that I immediately started hours and hours and weeks of going through this iPad to determine if we could recover any other information.
And did you determine what the issue had been with the passcode?
Yeah, it was two numbers that were inverted. It was something, I think the passcode was maybe, well, I don't want to say that,
Yeah.
but it was two numbers that were inverted.
Okay. And what investigative techniques, just in a simplified version, can you give us, and what, if anything, were you able to recover from the iPad?
Well, we already know that the victim had texted the mother through Google Hangouts because we had those messages. So when we first got the iPad back, the first thing that I started looking through was to determine if there was any Google Hangout databases within that iPad that stored the messages, the mirrored messages that would have been from the victim. Unfortunately, the settings weren't saved to save the messages on the victim's iPad. So I spent nearly probably anywhere from 80 to 100 hours manually going through every piece of data in this iPad, and I couldn't find the messages at all. In fact, I knew the messages because I had the words. I had the exact words in Spanish that were written to her mother right before she was murdered. So I used these as keywords, of course, to search the entire iPad, thinking that might be fruitful. Evidently it wasn't. So again, not wanting to give up, I was sitting at home, I was sitting at home one night, and this is what caused me to find the messages, and I was actually going through my own iPhone at home. So anybody that uses an iPhone knows that when you open an app and close that app and open another app and close that app, if you double click the button on the bottom, it shows which apps are open, and you can kind of scroll through these apps. It's about the same as whenever you're working on a computer and you have your email up and you minimize it and it goes to the toolbar. And then you have a video up and you minimize it and it goes through the toolbar. The apps are still open, but they're not visible unless you double click the button. Well, what was interesting is when I double clicked the button, I saw where I had my Google Maps up earlier in the day. And when I had Google Maps up earlier in the day, I was at the office. I was at headquarters. And when I looked at it, it still showed that I was at headquarters. And I knew this couldn't be right. And at that time, I basically had a forensic epiphany. I knew that that was a picture because as soon as I clicked it and the app went from being minimized to full screen, it immediately showed me at my house. So I thought at that point, was there any apps that maybe the victim had open? Maybe she had Google Hangouts open at the time of the murder. And I got very, very lucky because when I started searching all of the information and these pictures, I found that they were stored in not a JPEG format, but a PNG format. There was no documentation on this. I couldn't find anywhere in my forensic, with my colleagues or on my listserv where this has ever been used before as evidence. But what was interesting is I did find something from Apple, and Apple named this snapshot. So these are actually snapshots. And right before you close an app, Apple or the iOS takes a picture of that actual screen. And when it takes that picture, it stores it within the database of the app. So when I started looking in Google Hangouts database, not for the text of the messages, but started searching for PNGs, I found what we were looking for.
And what was
I found
that?
the actual messages that the victim had sent to her mother about someone at the door, and she thinks it's somebody, the man who cuts the grass.
So it was essentially a screenshot that you had.
It was. And what was interesting about the screenshot is actually whenever you type on an iPhone or even an Android, we know that whenever we start typing, the keyboard will raise up and you can actually see the keyboard where you're typing. It was such a screenshot that the keyboard was up on the screen. And the last message, we were just lucky enough that it wasn't covered up by the keyboard itself. We had both messages right there on that one PNG.
So that would be consistent with that being the last message sent on that particular application.
It was, and they were exactly the same times too. It was 4:15 on the first message, and it was 4:19 on the second message, and I'm so glad that we sent that to celebrate to have that done.
In just a moment. Thank you.
All right, Mr. Hopkins. One moment, Your Honor.
If I could have that piece of paper back for us to use for later.
Thank you.
Thank you.
To take a guess, all of your analysis that you do on these devices still doesn't tell you who sent the messages, do they?
It does not.
So it's possible someone else could have sent the messages from the iPad.
It is. The actual contact name coming to the mother was Yo-Yo, which I think was her nickname.
But as far as if someone had the app open and was typing on it, that wasn't Miss Ortega, there's no way of knowing that.
No, other than it was in Spanish.
Were there any other messaging apps on that iPad?
Not that I remember.
Were there any emails, accounts, or anything associated with that?
I think there was an email account for the little girl on there, but I didn't find any content after or the time of the murder.
Had there been other emails that day, other communications around this time?
Not that I found from the iPad. You have to remember and I do want to clarify this, there was no messages stored from Google Hangouts. So she had that device set up where it didn't store any data, the messages back and forth. The only messages that we were able to recover weren't really messages. It was the screenshot of the message that the system inside the iPad actually took right before that app was closed down. So those are the only messages that we have.
Is it possible that you could have simultaneous messages going in that and showing on different screens?
No.
That's all.
Anything further?
Not from this witness, Your Honor. We next call Patricia Velazquez.
Thank you, Judge.
She does not need an interpreter.
She does, Your Honor, and I think we do have the interpreter available.
Do you swear to tell the truth, so help you God?
I do. Would you please state your name and spell your first and last name?
Por favor, diga su nombre y deletree el nombre y el apellido.
Patricia Velazquez.
Patricia Velazquez.
If you could move the microphone just a little bit closer there.
¿Puede deletrearlo?
Patricia, P-A-T-R-I-C-I-A.
Patricia is P-A-T-R-I-C-I-A.
Velázquez, V-E-L-A-Z-Q-U-I-E-Z.
Velazquez is V-E-L-A-Z-Q-U-E-Z.
Ms. Velazquez, are you the mother of Johanna Ortega?
Señora Velázquez, ¿usted es la madre de Johanna Arteaga?
Sí.
Yes.
And do you have two other children as well?
¿Y usted tiene otros dos niños también?
Sí.
Yes.
In August of 2017, where were you living?
En agosto del 2017, ¿dónde usted estaba viviendo?
En Old Hickory,
In Old Hickory,
Bulletville, Tennessee.
Goodlettsville, Tennessee.
1229. ¿Cómo? 1229.
1229.
What type of a building was your home?
¿Qué tipo de edificio era su casa?
Una trailer.
A trailer home.
How many people lived in that trailer?
¿Cuántas personas vivían en esa trailer?
4.
4.
What were the ages of your children in 2017?
¿Cuáles eran las edades de sus niños en el 2017?
Oscar, 10 años. Joana, 12 años. Y Jocelyn, 14 años.
Oscar, 10 years old. Joanna, 12 years old. And Jocelyn, 14 years old.
Were you working at the time?
¿Estaba trabajando usted en ese momento?
¿En qué momento?
¿En what time?
In August of 2017.
En agosto del 2017.
Sí.
Yes.
Were there occasions when,
Your Honor, for the purpose of this hearing, I want to pose a leading question.
right, I appreciate that.
No ponemos.
While living at the trailer, were there occasions when you would have to leave your children
Cuando usted
without
estaba-
adult supervision?
Durante ese tiempo, cuando estaba viviendo en la trailer, ¿usted alguna vez tenía que dejar a sus niños sin supervisión?
Sí, cuando comencé a trabajar.
Yes, when I started working.
What were your rules for when you were not at home?
¿Cuáles eran sus reglas para cuando usted no estaba en la casa?
No abrir la puerta.
Not open the door,
No a tratar de no hacer ruido.
to try to not make any noises.
Si escuchaban que alguien llegara a tocar la puerta, no caminar por la trailer.
If they hear that somebody is coming to knock on the door,
Y no hablar a nadie.
they should not walk around the trailer and
No hablar, no contestar.
and not answer to anybody, not to talk to anybody.
Did you even have instructions about whether or not they were to make noise taking a shower?
Usted tenía de hecho instrucciones, por ejemplo, de no hacer ruido cuando se bañaban en la ducha.
De hecho, les prohibía que se bañaran cuando yo no estaba porque tenía miedo que se pudieran caer en la tina de baño.
In fact, I actually prohibited them to take a shower when I wasn't home because I was afraid that they would fall in the bathtub.
Were your children allowed to play outside?
Esos niños tenían permitido jugar afuera,
Solos no.
not by themselves.
Who had to be present before they were allowed to be outside of the trailer?
¿Quién tenía que estar presente para que ellos tuvieran permiso para estar fuera de la casa?
Solía ser yo.
It used to be myself.
Now, on August 10th of 2017, had the school year begun?
El 10 de agosto del 2017, el año escolar ya había comenzado.
Sí.
Yes.
And did your children go to a charter or a private school?
¿Sus niños iban a una escuela charter o privada?
Joana iba a una escuela charter y Jocelyn y Oscar, escuela magnet de escuelas de Natural School.
So Johanna was in a charter school, and Oscar and Jocelyn were in a charter, in a
Metropolitan School.
yeah, in a metropolitan school.
When you left, well, did Johanna go to school on the morning of August the 10th, 2017?
Johanna fue a la escuela la mañana del agosto 10 del 2017.
No,
No.
Why?
¿Por qué?
porque ella no podía caminar bien porque se lastimó patinando un tobillo.
Because she couldn't walk well because she got hurt skating, her ankle.
Was she on crutches?
Estaba usando muletas.
Sí.
Yes.
When did you leave for work on August the 10th?
¿Cuándo se salió usted para ir a trabajar la mañana del 10 de agosto? El día 10 de agosto.
¿A qué hora?
What time?
Yes.
Sí.
Un poquito antes de las 12 o a las 12
A
aproximadamente.
little bit before 12 or at 12 approximately.
Had you been alone in the trailer that morning with Johanna?
¿Usted había estado sola en la casa esa mañana con Johanna?
Sí.
Yes.
And when you left, was Johanna the only person in the trailer?
Y cuando usted se fue, Johanna era la única persona en la trailer.
Sí.
Yes.
What type of work were you doing at the time?
¿Qué tipo de trabajo hacía usted en ese momento?
Trabajaba en una dry cleaner, poniendo etiquetas y recibiendo pedidos por la computadora.
I worked at a dry cleaner, tagging and getting requests through the computer.
Was it normal for your children to text you and call you while you were working?
¿Era normal que sus niños le mandaran mensajes de texto o que la llamaran mientras usted estaba en el trabajo?
No.
No.
On August the 10th of 2017, did you receive a communication from your daughter?
El 10 de agosto del 2017, ¿usted recibió una comunicación de su hija?
Sí.
Yes.
Did you notice it or read it when it immediately came in?
¿Usted la notó, la vio, la leyó inmediatamente cuando eso entró?
No.
No.
And is that because you were working?
¿Y eso era porque usted estaba trabajando?
Fui a recoger a mis hijos, a mi hijo Oscar Josué. Estaba manejando.
I had gone to pick up my son, Oscar Josué, and I was driving.
At some point, did you have an opportunity to read one or more text messages from your daughter?
¿En algún momento usted tuvo la oportunidad de leer uno o dos mensajes de textos de su hija?
¿En qué momento?
¿En what moment?
At some point
En
later on,
algún
did you
momento, en
read?
algún punto del día, en algún momento usted leyó los mensajes de ella.
No recuerdo. De hecho, creo que es el único mensaje que me llegó de ella a esa hora.
I don't remember. In fact, I think that's the only message I got from her at that time.
But you did get a message from her?
Pero usted recibió un mensaje de ella.
Sí, lo
Yes,
recibí.
I did.
You've been handed a piece of paper with a printout from a download of your phone.
Le han mostrado un pedazo de papel que lo bajaron, lo bajaron del teléfono.
Do you recognize those text messages?
¿Reconoce esos mensajes?
Sí, estos dos.
Yes, these two.
Okay. And can you please say what those text messages say?
¿Puede decirnos qué es lo que dicen esos mensajes?
Mamá, alguien está tocando la puerta.
Mom, somebody's knocking on the door.
Creo que era el hombre que corta la yarda.
I think it was the man that cuts the yard.
Ok, no haga. Ok. Is the way es la manera como yo me expresaba con ella. Ok, no haga ruido.
Oki, which is just the way I used to talk to her. Oki, don't make any noises.
I could have that back. That last statement that you texted to her, is that the same rules and advice that you had previously on many occasions given your daughter?
Esa última palabras que le mandó en el mensaje de textos, ¿es eso lo que usted normalmente le aconsejaba a sus niños?
Sí.
Yes.
Thank you.
Carlson, can we make that last document exhibit for the purposes of this hearing?
Yes.
Sure. If we can hand that back to Ms. Velazquez. Now. Ms. Velazquez, the message that you read from your daughter, the first one says, someone is at the door, correct?
Señora Velázquez, el mensaje que usted leyó de su hija, el primero dice, alguien está en la puerta, ¿verdad?
Sí.
Yes.
And it appears about 4 minutes later, there's a second text, correct?
Y parece que más o menos 4 minutos más tarde hay un segundo texto, ¿verdad?
Sí.
Yes.
And that text says, I think it was the man who cuts the yard.
Y en ese mensaje dice, creo que fue el hombre que corta la yarda.
Sí.
Yes.
Which you took to mean that the person was no longer at the door.
Lo que usted pensó es que la persona ya no estaba más en la puerta.
En realidad no puse atención a eso, tan solo recuerdo que ya no me marcó y imaginé que se había ido.
I really didn't pay attention to that. I just thought that she just never called me back, and I thought the guy had left.
Well, I'm asking about, let me ask you about the words that she used. It is past tense.
Pero
correct?
las palabras que
Was.
ella usa está en tiempo pasado, ¿verdad? Dice, creo que era el hombre en tiempo pasado.
Así es, así como lo escribes.
Yes, that's how she wrote it.
And she did not specify which man, correct?
Ella no especificó cuál hombre tampoco, ¿verdad?
Ella sabía quién nos cortaba la yarda.
She knew who cut the yard.
Well, you also had a man that cut the yard in Greenbrier, did you not?
Usted también tenía un hombre que cortaba el pasto en Greenbrier, ¿verdad?
Ella sabe en qué lugares nos cortaban la yarda cada persona.
She knows in which places each person cut the yard.
But the question is, you do have a man who cut the yard in Greenbrier.
Pero la pregunta que le hago es, ¿usted sí tiene un hombre que corta la yarda en Greenbrier?
La cortó, sí. Sí,
Yes.
cortó.
And she did not specify which man that was.
Pero ella no especificó cuál hombre era, ¿verdad?
No.
No.
That's all.
All right. Anything further?
Hang on.
All right, you may step down. Each side, you want to be heard?
Your Honor, as the court knows, the state has outlined 3 hearsay exceptions why these text messages should come in. I think the third is the most powerful and the most convincing, but I'd still like to articulate briefly for the record and for the court what those 3 are. The first is the excited utterance exception under Tennessee Rules of Evidence 803-2. The excited utterance exception is often, I think, kind of misunderstood, and the meaning of it has changed a little bit in our courts because we're used to types of excited utterance like we're going to hear in the 911 call, which is someone in an extreme panic, screaming or crying. And those obviously are excited utterances, but the rule does not require that. Sometimes we impose too high of a burden. What the rule requires is articulated very clearly by our Supreme Court in State versus Gordon, which is the controlling case on excited utterances, and that there's 3 prongs. All we have to show is that there's a startling event, that the person is still under the excitement of the startling event, and that the statement that they make is in relation to the startling event. And interestingly, it doesn't come up that often, but one of the many factors that can be considered by the court in determining whether a declarant is excited is the age of the declarant, and also the circumstances that the declarant is in. The state's argument for this exception is that while it might not be startling for you or I to have the defendant knocking on our door while we're home alone, it certainly would be very startling for a 12-year-old girl who is home alone, who has been told by her mom to fear strangers and to hide from him in the house, to look out the window and see a strange man, the defendant, knocking on her door while she's home alone. In fact, we know she was startled because she thought enough to text her mom to tell her someone is knocking on the door. I think it's the man who cuts the yard, because she was scared. We just heard from Ms. Velazquez that the kids didn't normally text her while she was at work because she's busy at the dry cleaner. So we know the victim was startled when she saw him outside her door. It's sort of, the premise of half of the Hollywood scary movies of a young girl home alone and a scary guy lurking around outside. Of course she was startled by that. And these statements are made contemporaneously with her being startled. They're made while he's outside, and then 4 minutes later, I think it was him, as Mr. Hopkins pointed out. But these text messages come within minutes of him being outside. So these statements should come in under the excited utterance exception 803.2. The second exception is the state of mind exception. And I included a block quote in my motion from Supreme Court case, or from Tennessee Court of Criminal Appeals case, State versus Trustee 326 Southwest 3rd 582 at 603, because it's so applicable to this case, and I'll read that now. In that case, the court allowed the statements under the state of mind exception and said the statements the victim made shortly before her death about her fear of the defendant were relevant and admissible under the state of mind exception to show not only her state of mind at the time she uttered the statements, but also her probable mental state and behavior at the time of her death, including whether she would have been likely to initiate contact with the defendant or willingly accompany him in her vehicle. Well, we have the exact same facts here. Instead of willingly accompany in vehicle, it's willingly open the door. The state of mind exception is applicable to show the victim's fear of the defendant at the time he was knocking on the door, shortly before the proof will show this murder occurred, and that she would not have been likely to open the door for him. Finally, the forfeiture by wrongdoing exception under Tennessee Rules of Evidence 804b6, I think, is the most sweeping and most important one of the 3, although I think it should come in under all the 3. And under the forfeiture by wrongdoing, as the court knows, exception, under our rules of evidence, under the federal rules of evidence, under our Supreme Court, and under the United States Supreme Court, it has been well decided that a principle, an equitable principle of law in the United States and in this state is, if a defendant procures the unavailability of a witness by wrongdoing, they don't get the benefit of that witness not being here. You cannot kill a witness to keep them from testifying and then have your lawyer stand up and say, well, those statements don't come in because they're hearsay. And that's what the forfeiture by wrongdoing exception says. There's one of 2 reasons why the defendant entered that trailer. It was either to commit a burglary in the trailer or to commit a rape in the trailer, or both. But we know that he had to kill Johanna Ortega to make sure she couldn't be a witness against him, to testify against him in this trial this week, and that's why she's not here, and he should not have the benefit of that under the forfeiture by wrongdoing exception. Otherwise, we'd be sending the message to everybody, well, if somebody witnesses your crime, just go ahead and kill them, because then you won't be able, nothing they say will be able to come into court. So under those 3 exceptions to the hearsay rule, the state submits that these text messages should be shown to the jury.
All right, thank you. Ms. Hopkins? Yes, Your Honor. First of all, most of the state's argument is requiring the court to make a lot of assumptions that there have been no facts presented in this hearing to support. That she was afraid, there's been absolutely no evidence of that. The statement that she made under the exceptions that the state wishes to use here, one is excited utterance. relating to a startling event or condition made while the declarant was under the stress of excitement. There is no such proof, before Your Honor, that there was a startling event and that she was under any sort of stress when she made that. The then existing mental, emotional, or physical condition, Your Honor, the rule couldn't be more clear. It has to be a then existing state of mind, emotion, sensation, or physical condition. And it gives examples: intent, plan, motive, mental feeling, pain, and bodily health. None of those are in either of those two text messages. She is stating what the state submits is a fact, not a state of mind. Neither of those exceptions applies. Finally, even under the forfeiture by wrongdoing statute, there has to be proof that Mr. Coons engaged in wrongdoing intended to and did procure the unavailability of the witness. There's been no proof in this hearing of that he engaged in any wrongdoing, period. So the forfeiture by wrongdoing exception can't apply because there's been no evidence that he engaged in any wrongdoing. You've heard no proof of that. This was the hearing, present that proof, show that that exception applied. They didn't do it. So it is hearsay clearly. It's an out-of-court statement that they're wanting to introduce to show the truth of the matter asserted. They're not even saying it's non-hearsay. So the state's conceded it's hearsay. So the question is, does one of these three exceptions apply? They do not. Further, my client's right of confrontation trumps any statute, which is what a rule of evidence is, under both the United States Constitution and the Tennessee Constitution, which I've cited in my motion to limit. So he is unable to confront these statements, unable to cross-examine persons that made these statements for the very questions that I was asking the mother. Past tense. The other person, was she talking about someone who cut the other yard, that they had two lawn cutting persons? I can't ask her about, did the person then leave, because it appears that they did. So there's a lot of questions that I just can't ask of this declarant, and that violates his right of confrontation. So for all those reasons, the court should and must exclude these two text messages.
All right, thank you. Thank you both. As I stated yesterday, the court has reviewed this motion and the reasons behind the state's request to allow the text messages. And the court has been persuaded by the third reason, and that is forfeiture by wrongdoing. So I will allow it under forfeiture by wrongdoing. All right.
Thank you, Your Honor.
All right, are we ready for the jury?
We are, Your Honor.
I'm going to take 5 minutes, so we'll bring them in right at 10 o'clock.
Thank you, Judge.
The court will be in a 5-minute recess.